Good morning. Welcome to our continuing hearings on the bill. We're going to just break until about probably 10:15. We're waiting on the ranking member, and she said she'd be about 10 minutes late. So we're going to start in about 10 minutes. Thank you. Okay, once again, we are opening our continuing hearings on the bills that we retained. And this morning, we're going to be hearing from some more folks from the county, and I would invite them to come up to the table. If you wish to testify together, you can just pull up another chair, and that'll be all. And just please identify yourselves for the committee.
Good morning. Joe Costanzo, the superintendent at Hillsborough County Department of Corrections.
Tim Considine, I'm the booking and records supervisor.
So if you could, whether or not you're aware, we've retained about 5 or 6 bills that have to do with bail, changing the conditions of bail, things of that nature. And what we've been asking the counties, because the counties are the folks who end up with these people after they've been arrested, waiting for bail or returned after bail. If you could tell us your involvement in that system, what, if any, kind of pretrial programs you have, how you deal with people that are on bail, and how it impacts you, and how any changes could impact you. We'd love to hear it.
Well, good morning again. I can talk to this, I guess I would say, from my experience, obviously working in corrections. I've been in it for a period of time now. Every facility is a little bit different. Different counties are a little bit different. 10 jails, 10 superintendents. But when it comes down to the basics of what we do as corrections, and that is the safety and security of the institution and of the community. Over the years, we've seen drastic changes in our populations. One stems from bail reform, one stems from COVID, where our populations really dropped. And when I say really dropped, they would go from an average daily population someplace down in Hillsborough prior to me getting down there. I do want to say that. I was previously the superintendent at Merrimack and up until July of 22, August of 22, and then I transitioned right over to Hillsborough. So I've been there just a little bit over a year. Their population used to sit around, I would say, probably 400, 500 daily population. When I got down there, we're hovering in the mid 200s. I can tell you today we're at 340, roughly around 340. The impacts of the bail, I will say in general, and I think this is a good platform to have this discussion, is we are seeing individuals come in the worst medical conditions that we've ever seen them. I have ever seen them in my experience in corrections. When you talk about costs, that's a large part of that. Now, I had previously. We've had discussions amongst the superintendents. As you know, it's very hard to lock down what an average daily rate is for a individual in custody. I mean, there's a formula you can break it down with. That's, you take your budget, you break it down by 365, and then by that you break down how many inmates you have, and you come out with an estimated cost. So let's just say if it was $155, right? The problem with that is to give an actual estimated cost like that is we could have one individual, for example, that would cost us $30,000 a month in medication costs, depending on what they're on. So when I'm saying that the impact of and what's been going on in regards to bail and what we're seeing and the impacts at the level of the stakeholders in the county jails is that medical needs to be, medical is something that you definitely need to be mindful of. And then also, in regards to the cost per day, that's the largest driving factor. I'm gonna say that. My experience, and I'm gonna ask Lieutenant Considine to talk a little bit. Experience in regards to pretrial services. Hillsborough currently does not have a pretrial service program. My understanding is that at one point there was talks about it. But at this point in time, it really boils down to funding too as well. There's also a lot of other pieces that have to be put in place with that, such as who's revoking their bail status while they're out on pretrial. Do correctional officers actually have the authority to go out and take somebody in that's on a pretrial status? to my knowledge, that that there isn't any RSA or authority that we have to do that. So there's a lot of mechanisms and staffing that would need to be put in place too in regards to that, which all boils down to one thing, and that's funding. So is it something that the county would look at in the future? That is something that I would request that we respectfully have to have a conversation with our commissioners and with our funding authority, the delegation, and the executive committee. Currently, right now, we do have, I know there was questions about electronic monitoring programs and so forth. Electronic monitoring, for us right now, we utilize it for sentenced individuals, individuals who are on our programs and out in the community. We monitor them in the community. It costs us roughly $6 and I think 37 cents. If you just remind me for a second, I actually have the number right here. Costs us, I'm $6.85 per day to keep that monitor on that individual. So obviously there's a shared cost that's associated with that. So we obviously, the individual that's out has to repay that cost while they're out. Now, there is, that it doesn't sound like a lot, but when we talk about reentry and putting people back into the community, holding stable jobs, especially those who are experiencing substance misuse, that can be challenging. That can be very challenging. So I guess that's a brief overview. I mean, I'd be happy to answer any questions. I can ask Lieutenant Considine. I know some of the questions were how do we interact directly with the bail system. So those individuals that are coming to our custody, we see a various range of preventative detention, cash bails. We see a lot of PR bails, and we're seeing a lot of repeat individuals coming back in. And as I said, their condition has just worsened over time, which eventually by the time they hit that mark of they're being held for a period of time, again, they're on pretrial status, but they've reached a mark where they're definitely going to be more costly than they ever have been. And that's just my observations as a correction professional and as an expert in corrections. I think that just needs to be noted. So do you want to talk about how we interact with the bail system?
Yeah, so right now, I know one of the problems we're facing with the bail system is the lack of available bail commissioners that are online on any given day. I know we have a handful that we use at our facility, and we frequently run into problems where we have to redirect people to the courts to have bails posted rather than being able to call a bail commissioner down to the jail to post it because there's just no one available. Sometimes we have a good relationship with the bail commissioner, so sometimes we can get a hold of them and have them volunteer to come in on days they're not necessarily working. That has been a hang-up with the bail process as it stands now. And I know there's several reasons for that, for the lack of bail commissioners. I'm sure they can speak more to that than I could. But that is probably our biggest hang-up with people who are actually being held in jail getting out. I know we're seeing more PR bails come in and go out than I have at any other time in my 18-year career. It seems like it's often the same people, once a week. We see them, we say goodbye to them, we see them again the next week. It's just in and out. And as he said, I think that's leading towards a lot more medical issues. I think years ago it used to be a rarity that we'd send somebody out to the hospital or not accept someone at intake. And now it's just, we know these people when they come back, and we know, as he said, the conditions are just getting worse and worse. So it's, they're coming in, they're being deflected before they even they have to get medically cleared with us before they can come in. So the police departments have to take them over, and we have to try and arrange the arraignments with the courts and get that settled. And then we go through the whole process of getting them stabilized and back, and then it's another PR bail and they're back out on the street, and it's repeating that cycle over and over again more often.
One of the things, and I'm sure you asked some questions, but obviously with the felonies first rollback, that's going to bring on some drastic changes as well. We've already began our meetings with the public defender's office, or excuse me, with the clerk's of court's office, and I have a couple meetings with my heads of local public defender's office. I know the head of the public defender's office is in the back right there, so And just trying to navigate that process. It's going to go essentially back to the way it used to be. Um, so obviously, there's going to be some changes in that status, and that will affect us as well too, and operationally. So
How do you see that affecting you?
uh, I I I think there's obviously going to be a lot more in and out. I think there's going to be individuals when you're doing the bails at the when they're seeing at the circuit court level. Um, a lot of those charges are going to get kicked up to the felony level. We could see our population increase, but we could also. It's hard to say, put my thumb on exactly what's going to happen, but it affects us also time-wise. Right now, if you look at a county like Hillsborough, I mean, the other day we had, for example, we had 30, roughly processed 30 people in and out in one day. That's staff intensive. I mean, it's our job. It's what we do. Um, Video arraignments, we have the capability of doing video arraignments now. Um, when you talk about two of the largest cities in New Hampshire, Manchester and Nashua, feeding into one county jail, all those arraignments are going to happen roughly, probably within the same time frame, and that'll be tasking on us, not only tasking on us, but it'll be tasking on the public defenders as well too. So that's how we see it impacting us. So
How many rooms do you have available to conduct video arraignments?
we have two designated rooms that we have to conduct. Actually, they're getting rebuilt right now to be able to conduct that. But we utilize tablets. We can do them right on the housing units. So we've taken some large steps in that technology advancement over the years and gotten creative in that way. But that still wouldn't negate the fact that obviously those individuals are going to need to meet with counsel prior to it. So we need to be mindful of that and letting the counsel get in and speak with them prior to the hearing and so forth. So
Does counsel have the ability to also confer with them privately over a video if they're not able to make it into the jail for that?
currently right now, we've had cases where we've made exceptions for that. One of the big issues that we've seen, and I know, and I will speak from the DOC's standpoint, is if counsel hadn't had a chance to speak with their client, sometimes they have to ask everybody to step out of the courtroom, and that just delays the process, right? So that's not a practice that I think that the clerks moving forward, I think is really good because, or is wanted, because it's just going to continuously have delays. So we need to be able to provide them the ability to come in and meet with their clients. I'm sure, obviously, if that was the option and there was a question about that, we could work on making exceptions to that. They do have access to call them. They have direct access to call them. There's a couple lines in the jails where they can call in. Also, they have access on their tablets where they can reach right out to their public defender and speak to them prior. So
Okay, so thank you. I have just a few questions. So when you talk about medical costs being the real driving factor, what kind of medical conditions? Are we talking mostly mental health, or what's the biggest driver of that?
so the biggest driver that we're seeing is obviously mental health is a large driver. Substance misuse is a large driver. But what we're seeing medical conditions individuals coming in with is infections, which are requiring significant hospital treatment because they haven't been treated prior to coming in, and they've just let lapse.
Like sepsis type things from
Sepsis is a large
injections?
one. You're seeing people's communicable diseases, HIV. There's numerous just chronic conditions that have never been treated over the years or have been neglected over the years, that just lead to organ failure. So many different things.
Just
I mean,
everything that you can
it's
imagine when somebody's
everything you
homeless.
can imagine. We've seen it, and when we say that, then we see something else.
So, how do you screen that? Obviously, you can't just look at someone and see that they are HIV. How do you get to that process? When are they screened?
So currently, right now, Hillsborough County has brought in a new medical provider. So we share the same medical provider as Rockingham, Carroll County, Belknap County, Merrimack County. But even prior to that, they're screened at intake. So as the PD arrives at the facility, prior to admittance, they're screened. If there's criteria that we look for, say the individual is in a car accident or so forth, they're unstable in their feet, they have a head injury, they have open sores, open wounds, we require them to be cleared by the hospital prior to incarceration. Still, they're going to come back to the jail. And then there's a medical intake that's done within the first 4 hours now. The medical intake is done at the facility, an initial triage medical intake. And then within 48 hours, they've had their medical intake done.
How do you handle people that come in who have mental health issues, who have been, like, for example, someone with schizophrenia who's off their meds? How do you deal with that?
It's definitely a difficult, I can't commend our staff enough, and correction officers all over the state, just dealing with these individuals that are in crisis. It's unfortunate, but, between utilization of CIT, crisis intervention techniques, and trauma-informed training, our staff have been able to de-escalate those types of situations. Jails aren't established to be long-term care facilities for individuals with mental health. It's not what we do. We're established, what we do is triage and stabilize until they can require the proper necessary care, whether it be at the New Hampshire State Hospital or sometimes the secure psychiatric unit. But in the meantime, obviously, we're the first stop. Unfortunately, jails in the country have become warehouses for those who are in crisis and suffering from mental health. And the way that we process it and the way that we deal with it is, we have clinicians on staff. Our medical provider, we continue medications, we get them started on medications, they meet with the provider, they meet with our psychiatric nurse practitioner. And that we do all that via video too. We can do that. We have the ability to do telemedicine too now. So that's how we interact with those individuals coming in. So, and it takes a lot of patience with our staff too as well, and connecting to make sure that we're not escalating them in their crisis, in their state, and also providing them a safe environment as well for our staff, a safe environment. So.
Do you have facilities to hold someone where they can be safely held without hurting themselves if they are in a mental health crisis? Without using like padded room, something.
So we do have areas that provide more observation for individuals, such as larger Lexan cell doors. We have protocols in place for those who are experiencing self-injurious behavior, and requirements of what they would for clothing, food, how they're processed, interacting with staff. So we have secured cells that obviously we can utilize. Yeah.
Have you or are you aware of any way for you to recoup some of your medical expenses if the person has, for example, Medicare or Medicaid to bill to get back for some of that?
So thankfully, when an individual leaves our custody, like so if they go to the hospital, we can turn their insurance on. They have to be admitted though. What we see a lot, and I will speak very candidly about this, is they get placed in an observation period, and we can't recoup during that observation period. However, if they're admitted to the hospital, the state has worked with us, and their Medicaid will cover their hospital costs. So it's only if they're admitted though. Other than that, when they come in, their insurance turns off. When they leave, we turn their insurance back on for them. And obviously, as most of you are probably familiar with, this has been a hot topic over the years in regards to insurance and so forth. So, but yes,
It would require the federal government to pass a law that would not, that would allow you to continue billing even if they're insurance. Because it seems like that law was designed to penalize people for going to jail, but if it's a mental health thing that drove them to jail, cutting off their insurance seems counterintuitive.
the cost is shifted down onto the counties at this point.
Do you get any money from the state to recoup any of these expenses?
Any specifically in regards to mental health, I could tell you
Or
right now.
Anything?
Yeah, we applied for the opioid funds
Yeah.
this year, and we were awarded some reimbursement prior to this as well too. Prior to me getting there, there was a sum of money that the Hillsborough County was awarded, and we're in the final stages. It's going to GNC. I think November 3rd, I think is the next meeting. So there was a recoupment that we applied for a 3-year period for funds. Yes.
Would it fully reimburse you or only a little bit or?
No, it would reimburse such costs as medical assisted treatment, cost of some of our staff time is a percentage of it. But mostly it was surrounding around the cost for our providers to provide the medication assisted treatment in the facility. So
When you mentioned a person who might cost you $30,000, are you talking like a person with meds, like who's on HIV, who has to take a lot of med?
you can look at a med like, I mean, we've all seen the commercials for it. You look at a med like Humira. Those are suffering from long-term. I can't forget the name. I'm sorry, but you took a med like that, on the street. And when I say on the street, I mean outside of
Yeah.
the jail. If you don't have insurance on it, it's about $30,000 a month. So.
Yeah.
We could go to the provider, we all have insurance and we go to the provider, we pay like $40, but those individuals, that it's a very expensive cost. So
You pay full price?
if we would,
Yeah.
yeah.
Have you tried reaching out to any of the pharmaceutical companies and had any success with them? Reducing?
So we utilize, like currently right now, our medical provider has a pharmacy that they utilize. Westwood Pharmacy is what they do. There's other jails. There's other jails use different pharmacies. It all depends, on what the cost is. We go out to we utilize the RFP process for that as well.
Yeah.
To get the best price on those medications. A lot of the companies are able to restock unused medications, which provides us a kickback, obviously, and reimbursement. So,
Okay. My next question was regarding tracking do you have any ability to track if someone is let go on PR and they come back 3 or 4 days later? Are you able to track those numbers of people who reoffend and come back in while they're on an original bail?
We can certainly track an individual who's released and when they come back in, based on that, just their inmate number, we can see how many times they've been back and how recently. As far as just a general tracking of whether or not unless we're specifically looking for it,
Yeah.
it wouldn't necessarily come up. Once they're on PR bail, they're out of our system. We're not tracking them at that point. So it's not like I couldn't pull you a number right now and see how many inmates we've released on PR bail that are still out on PR bail and or how many times they've come back well out on bail. So
Would your system be able to do that if that were something that were required?
it could assist with that.
Just so that we would be able to get
Yeah,
a number in the
so, I mean,
future, like over
there-
a year, how many people are let out and then come back while they're still on their original bail?
Yeah, we could use the system as well as some other resources that we would have to use to track that information, but that could be done over, if it was done intentionally over a period of time.
Okay.
So,
yeah.
I ask because I don't want to mandate something that can't be done without funds, so. Go ahead, you wanted to say something?
Yeah, one of the things I would note with that is that those arrested in other counties. So we won't know necessarily that somebody was arrested in Rockingham County.
Yeah.
And we see that when we do our recidivism numbers for like our programming and so forth. Because the national average, I believe, is around 60%. And then, for a place like Hillsborough County, when we did a recidivism study this past year, in our program, we're sitting about anywhere from, in 3-year period, 27 to 30% recidivism. Those are sentenced individuals that reoffended within 1 year of coming back to the facility. And Lieutenant Considine is our data individual. So he's the best person for us to be asking this question of right now. So.
Okay, I want to keep in touch with you.
Yeah. He, but to track that within our county, I mean, it would take some legwork on our end, but, he'd be happy to take a look, I'm sure. In the
If you
system.
could, if it's possible, I don't want to ask you to move the world, but if some retooling of the system is possible so that you could track individuals who came back while they were out on bail, so we would have harder numbers on that. Let me see. With regard to, you said that you have some difficulty getting bail commissioners. Is that something new that's getting worse, or is it something that's kind of been steady in the county?
It started, we used to have, I want to say a couple of years ago, we used to have a bail commissioner on 24/7 that we could get a hold of, and we share a bail commissioner with Manchester PD, so they would swing back and forth between each of those, and probably starting within the last, sorry, just time blurs together, so sometime in the last couple of years, it went from us occasionally having a day where we had no bail commissioner on to, it's ebbed and flowed a little bit to, we oftentimes have multiple days a week where we have no bail commissioner available.
Would that be over a weekend that you're talking about mostly?
Very candidly, I'd like to say this, one of the things I noticed one day, like over Memorial Day weekend, I believe it was, I want to say it was Memorial Day weekend. There wasn't a bail commissioner on from Thursday till, I think, Tuesday of the following week. So we didn't have anybody that we could call, and that's not only frustrating for us, it's frustrating for the I would assume, I don't want to speak for them, the public defender's office, as well too, and also the PDs, because people are on vacation, and that's what people do. People take vacations, and when there's only a limited amount of bail commissioners, that becomes an
So
issue.
that whole weekend, people that would normally be entitled to bail had to sit in jail the entire weekend?
I think we were able to get a hold of a bail commissioner, in a couple accounts, but again, they would either sit with us or they'd sit with the PD.
Yeah,
So.
if they have a holding facility. I'm going to ask about everybody in a second. With regard to electronic monitoring, do you see any bail commissioners ever avail themselves of that as a condition of bail? And if so, who would monitor it?
So we've seen it utilized, the company, off the top, what's the company that we have? Paris Bail Bonds out of Connecticut have done that, has done that in Hillsborough County. And they would come up, put a bracelet on, or they'd have somebody in the area put a bracelet on them and monitor as a condition. Usually the condition comes down from the courts though. in
Okay,
regards to that.
that would be in a cash bail situation probably, when they use the bail bonds out of
Usually,
Connecticut.
yes.
Okay. If it were utilized by bail commissioners, as part of a PR bail, would it still be the same $687 a day?
That cost varies, in my experiences throughout my career. Again, you go through, it would all depend on what that company chooses to charge them. And also whoever they're utilizing from, like what monitoring system, there's multiple ones. There's Sentinel, there's Track Group, OmniLink, there's so many different, groups out there that do it. So it really would require who's given whatever price they're getting versus how much they're charging. So.
Well, the committee, I mean, candidly, we're here because the public has expressed a certain level of uncomfortableness with the number of people that are being bailed, released, and committing crimes while on bail. And at the same time, we're looking at how we can not say, okay, you're all going to be held at the expense of the county, and also to disrupt people's lives unnecessarily. I feel like electronic monitoring implementation would be much cheaper to the county than having them stayed in there with all their medical expenses and everything else. So we're trying to look at that as a possibility versus just being held on certain crimes.
It definitely would be a cost shift to the county, obviously with that, because it would require staffing as well too.
Yeah.
And, you know, one of the things that there's obviously would need to be conditions that would be met to put somebody out in the community, because you would still see the same thing of them coming back and continuing to come back. I mean, it would need to be monitored while they're out there. We have utilized it in instances, very specific instances, where somebody's medical situation is so drastic that it would require hospitalization for an extended period of time. We have, and the Public Defender's Office prosecution have worked with us in order to allow us to put a bracelet on them and keep them there, which has shown a large savings to the county. So it does
Well,
have.
that's what I'm asking.
Yeah.
Would it be more cost effective for the county to hold somebody, hold them actually, or to continue to let them on PR but with a monitor? And it seems to me the monitor would be much more cost effective than,
Again, I think it would be.
I mean, either one is going to cost you money.
Either one's going to cost. It would definitely vary on the person, on the individual too. And
Yeah.
that's the hardest part to
Right,
say.
will they obey
yes or
their
no?
other
Yeah.
conditions regardless? So, yeah, okay. Questions from the committee, Representative Rhodes?
Thank you, Mr. Chairman. You had mentioned about the lack of bail commissioners. It's not the first time we've heard that. I'm sure you understand that. How many times, or I guess how many attempts will you make to call a bail commissioner before you just, like Hillsborough out? Like, how, like, are you doing this, are you calling every hour? Or are you just calling 2 or 3? Like, do you call 2 or 3 times and then that's it? Like, what would be your norm or your standard?
If we have a bail commissioner scheduled, we'll call them repeatedly. If we have no bail commissioner scheduled, our first call is usually the Manchester Police Department to kind of see, hey, are you guys, to see if they're using anyone, if they've already talked to somebody who can come in. And after that, if they say, no, we haven't used anyone, then we'll kind of cold call some of the bail commissioners that we know on their days off that aren't scheduled to see if they're available to come in. And if they answer and agree to come in, then that works out for us. If we call around and we can't get through to anybody, then there's nothing else we can really do at that point.
Yeah, I found in my career too, there's certain bail commissioners that, that will go above and beyond and come in and, as you work in these agencies, you develop that relationship with them. And because our goal isn't to hold anybody that for bail, that has the ability to get out on bail, because again, that becomes a cost for us. There's potential liability associated with every individual that we house in custody too. So if we can get them out, we want to get them out. So.
Just to follow up on her question, do you have like do the bail commissioners in your county, do they have like who's going to be covering this weekend or any type of that thing? Or is it just, you just start calling down a list?
They send us a schedule monthly and then updates as they need to.
Thank you. How often are you seeing individuals with their bail being violated that are detained until they have trial, either at misdemeanor level or felony level?
That come in on violations of bail.
Yeah, they come in violation of bail, their bail has been violated. They come back with either a cash bail from the court or they end up staying with you until they have trial. Is that something you're seeing a lot of recently or no?
We do have a fair amount of individuals coming in with the breach of bail charges. Unfortunately, I wouldn't feel comfortable giving you a number as far as how many of what's that turns into after they're arraigned. I would have to, it's not something I've necessarily looked at this point, so.
I would just like to follow up on that. I will give you a number. I think it was my last board meeting. It was roughly, I think, 28 people that we had in custody that were in custody for over 365 days as pretrial. That's a lot of individuals. And obviously, there is the whole court process with, all of the court proceedings going on. But that's a lot of individuals to be housing. Jails aren't designed to house people longer than a year. That's just not what we are. So,
You follow up? I would assume those cases are probably felony level cases that are more serious in nature
Most of
than
them, yes.
misdemeanors.
most of them, yes.
All right, thank you.
Any other questions from the committee? Representative Wheeler?
I just missed the number when you had said it. What is the recidivism rate for Hillsborough County again?
So if you look at the national level, I would say the national level roughly is around 60%, 65%. when you look at our program, and I was talking specifically previously what was known as SACO, there were 3-year recidivism studies. So those individuals that were sentenced to our SACO program, and our numbers are right on the website too. So if you want to take a look at this, all the data is right on there. And it's very interesting because it breaks down what they've been brought back in on, probation holds, new charges, and so forth. Hovered between 27 to 30% recidivism for those that were sentenced in our program. So obviously the program is working, and we've revamped it and made it a little bit more robust now, and we call it the ACT program. So it's available to those individuals that are sentenced. Right on the county website. If you go on to Hillsborough County, if you go under the Department of Corrections, and it should be under the ACT program, there's a slideshow talks about treatment programs inside the facility, and you can see the data right on there. And that was Lieutenant Considine who did that. So.
Thank you. Several other counties we talked to seem to have some pretty successful pretrial programs. Have you been in touch with them? Are you aware of what they're doing? Some of them seem to be actually realizing significant cost savings by utilizing that.
As I stated earlier, I came from a county that was utilizing a pretrial service program. It definitely has come. It's definitely continued to evolve, and I mean I have seen it. I will say that I have seen it. Again, it would be the will of the commissioner and their funding authority about because it will cost us some more money. Obviously, there's a cost associated with operating a full-time pretrial program. So.
Having probably the most turnover in the state as far as people coming in and out.
We have the largest facility. We probably process the most people in and out in that facility on a daily basis than any other facility in the state. So we do. So.
If the state made a fund available that had certain requirements that a county would have to meet to apply to that fund with regard to a pretrial program, do you think that would something that would be interesting to Hillsborough County?
I would urge us to approach the Board of Commissioners and the delegation about that, obviously, because it's a cost associated with it. So.
I mean, okay, pretend they all said yeah. But is it something that the DOC would find?
I think you find it would fall back on how the program's going to operate. I think there would be a lot of research that would need to be done into it because most programs operate differently. I know Merrimack's operates underneath the Human Services Department. Stratford operates out of the jail. Rockingham operates out of the jail. I know Merrimack used to operate out of the county attorney's office. So I think it would just be a collective approach within the county that multiple agencies would have to, and stakeholders would have to buy into and figure out what process works the best for Hillsborough. So.
Yeah, I was thinking more of the state looking at doing that legwork and finding the best practices and saying, okay, look, we've got X number of dollars. If you implement a program that has these things, you can be eligible to apply to that program for money to reimburse you for running it. Would that be something?
I think everybody wants to save some money, so,
Yeah.
and get some money from somewhere. So,
Yeah.
I think that again, I just think it would be a conversation that would need to occur with the funding authority and the Board of Commissioners.
Representative Stone.
Thank you. You happen to spark my interest on something. Given the circumstances where each county operates independently and sets their own programs and parameters, and we've heard testimony last week where you think it was Merrimack and Stratford, and when it came to violating the pretrial, one would be a letter sent to the court and another one would be sent to the county attorney. Would it be better served in your experience that maybe the probation parole department for the state would be expanded on to include, making it a bigger umbrella, to include pretrial confinement monitoring rather than putting people in jail?
My experience, and I know this is a question that we had asked about probation and parole. I know from my experience working with probation and parole, and speaking with them, obviously it falls under the state, that they are stretched really thin right now. I don't know if they would have the resources to do that. If they were to expand their resources, then I would say that would probably be a conversation with Commissioner Hanks and Field Services Agency. So, I mean, it could go two ways, I guess I would say. There's going to be a cost to either the county or the state at that point.
Are they doing the same job function?
It would be the same whether New Hampshire doesn't have county probation. If New Hampshire was to go down that road of county probation, obviously there would be funding associated with that as well too. So, and that would shift the cost from the state down onto the county. And obviously there would need to be some cost shiftings and saving to the county if they were to take that over. So,
Thank you.
It just, the observation that I mean, I'm not going to speak for the committee, but I have seen during the hundreds of hours of hearings we've had, first of all, I'm a state representative, but I'm also a citizen of a county. And it seems to me that the states is creating laws that make crimes, sentencing people for breaking those laws and telling the county to pay for it. And is that pretty much accurate? I mean, very loosely speaking.
there is some cost shifting, yes. And the
Um,
cost shift comes onto the county.
And it could be a citizen from another county who lives his whole life in the other county, commits a crime in your county, and now he's a citizen of
I
your
will
county
give-
until he's
I will
released.
give you a very clear example. Parole violations.
Yeah.
Individuals with parole violations that pick up new charges. They are responsibility of the county, but yet they are on parole violations.
State
They are
parole.
not picked up until those county charges have been resolved. So that individual who's under parole supervision, I understand they picked up new charges, but they're still under a state prison sentence and supervision. And that gets transferred down to the county. And we sit on them until all those charges are resolved.
So if they were not on parole, they would have been eligible for just bail and it would have been routine
Or
process.
they'd still be eligible for bail, and they're still eligible for bail on their new charges. If they get bailed on their new charges, we would transfer them to the state prison. If they're not bailed on their new charges, then they sit with us, even though they were parole.
Representative Stone.
And I can't imagine a lot of people want to pay bail to end up at the state prison.
Have you had people decline to take bail?
I've seen people decline bail over my years, yes.
Thank you. Any further questions from the committee? Seeing none, thank you very much for your testimony today.
Thank you very much for your time. It would be.
And at this time, we have somebody from the Public Defender's Office here to talk to us. And I know you have an incredibly busy schedule, and I really thank you for taking the time to come.
Thank you. Good morning, everybody. Thank you for taking my testimony this morning. My name is Sarah Rothman. I am the Executive Director of the New Hampshire Public Defender. I've been with the Public Defender for 16 years, and I've been in my role for about a year, a little bit over a year. I think I had the opportunity to speak with you some months ago at the beginning of the session, just to kind of give you an overview of what the Public Defender does. But just very briefly, I can tell you, we are sort of the one-stop shop for, public defense or for criminal defense in New Hampshire. We represent roughly about 85% of all criminal defendants in the state of New Hampshire. We exist by statute. There's a statute in New Hampshire that says that the state shall contract with a law firm to provide defense to indigent defendants. And we bid for a contract every 2 years. We are a private nonprofit law firm. We bid for a contract every 2 years with the Judicial Council. And then obviously, we're also, aside from statutorily required, also constitutionally under the federal and the state constitution required for anybody facing potential jail time to be afforded an attorney if they can't afford one, and if they qualify after applying with the court. So I, again, thank you for the opportunity to allow me to address from from my perspective, from the public defender's perspective, some of the issues with the current legislation that's pending with with regards to bail. I do want to say, at the outset, I kind of want to echo a lot of what the previous testimony, which is that the changes, the proposed changes to the bail statute simply cannot be sustained financially or logistically by the public defender, by the prosecutor's offices across the state, and by the courts. I hope that I can impress upon everybody that the significant change that this will represent, the significant volume increase that this will represent. And I also want to try and impress that it would be a change without need because of several factors that I'd like to get into this morning. So I think it will cause, an explosion of the number of bail hearings that my office would have to cover. Sure. So the list of, there's different bills have different lists, but adding 12 to 13 offenses that you are just prohibited from seeing a bail commissioner for and must be held until you can go in front of a judge. So those are people who right now, and I understand that you've heard over the weeks testimony about the lack of bail commissioners. And certainly I think that there's a lot of solutions we could bring to that particular problem that do not involve just cutting out bail commissioners. Bail commissioners, even though it's a resource that is limited, provides a really important function in the system, which is to evaluate whether people actually need to be held to see a judge. And if we create, 12 or 13 statutes that they are just not allowed to see a bail commissioner, we are going to see a huge explosion in the number of incarcerated bail hearings that my office will then have to cover on a daily basis, that prosecutors and judges and court staff will have to cope with. And the reason that these people, when they see a bail commissioner, are currently released is because, they are a good candidate for bail. So these are people, this volume of people that we're currently not seeing, we're not seeing them because we don't need to see them. And I want to get into that a little bit further. But just to kind of start at the outset to talk about the impact that this would have, financially, and I guess I can't speak in too concrete of terms financially, except to say that this will require us to have more staff and require a lot more attorney time from us. Right now, whether I'm prepared to kind of quantify that in a dollar amount, not necessarily, but I can say more is a good way to say that. I guess I would also encourage everybody, if you haven't already, to look at the fiscal note that's there for Senate Bill 252. That's also pending. That bill has a fiscal note from the judicial branch about the impact of adding all of these statutes to a list of folks who will not be able to see a bail commissioner. So, if they're not able to see a bail commissioner, that means that they need to have a lawyer appointed to them. Obviously, these folks would have a lawyer appointed to them at some point anyway, but these are, what we often refer to as same day or next day hearings. So these are defendants that we find out about in the best case scenario, late afternoon the day before, but in almost all instances, the day of the hearing. So, sometime in the morning, we get a list, and then slowly paperwork starts to trickle in, the charges against the person and an arrest warrant affidavit. And then there's a whole process that we have to go through on our end to conflict check and to get a lawyer present to represent that person. And then, as you've heard briefly earlier this morning, there's the logistical issues in being able to talk to that person prior to their hearing. And sometimes, we work county by county to create systems to try and be able to do that. But those systems are not perfect, and it can be very difficult to access our clients before these hearings. And particularly, there's in an ideal world, there's back and forth, right? You talk with your client, you find out some information, and then you talk with the prosecutor, because it is possible to negotiate bail or to negotiate conditions of bail. And so then you talk with the prosecutor, and then, you want to talk to your client again, and you're lucky enough a lot of times to have one conversation with your client before this hearing, and let alone another one. So there's this whole process that has to take place that we already do, but now we are talking about expanding that to a whole population of people who otherwise could have had access to a bail commissioner and potentially not be held and not need that same day hearing, which will take time and resources from the public defender, from prosecutors, and from court staff. We are, and I don't want to sidetrack us too much on this, but the public defender continues to struggle with our staffing levels. We continue to face very, very steep attrition. We have lost, since July 1, as of tomorrow, we will be down 9 attorneys since July 1. As of November 1st, we will be down 10 attorneys, and as of January, we will be down 12 attorneys. And so people, and at the last fiscal year 23, we lost 22 attorneys. So by January, we will already be at 12 and counting. So it is already, difficult for us to staff the workload that we currently have. I think that some committee members might be aware that during the pandemic, we had to put certain categories of cases on hold to wait assignment of counsel. We have largely cleared that list and are now back to assigning cases upon receipt from the court. But caseloads among our staff are consistently high again, and then it feeds this cycle of attrition. The workload is too much and too stressful, and the pay is not enough, and so people leave. And it might seem kind of abstract to tie changes to the bail law to increased attrition at the public defender, but it's not abstract. If we add in additional, bail hearings on a daily basis, we're already going to be doing bail hearings, but even to get sometimes an agreement on bail for one client can take 2 to 3 hours. And so now if you're trying to do that on behalf of 4 and 5 clients, because there's people who did not have access, were not allowed to see a bail commissioner, then we're talking about half of or more than half of your day working on just bail hearings, when you have a lot of other kinds of hearings. You have to go to the jail to meet with other clients, you have motions you need to write, all of the other things that we need to do during our day. And so I want to emphasize that, the system has had, reached a breaking point a couple of years ago, and kind of buckled, and we've kind of tried to claw our way back. But as, you heard in the previous testimony, as of January 1, there's already going to be significant change to the system that I think will cause arraignments and bail hearings to be more time consuming as it is for our office. And with these changes, if these proposed changes with creating a list of 12 or 13 offenses that are automatic holds, people are not entitled to bail until seeing a judge, it's going to be difficult to impossible to staff and sustain that work.
Felonies first change.
Yep.
How is that going to impact your office, if you could? It's
Sure.
my understanding that in the first instance, felonies were being heard in the Superior Court. Now they're all shifting back to the Circuit Court. Would you not have to appear at either one of those, or what's the difference that on
Right.
your?
Yeah, that's a great question. So, right now we staff the felony arraignments in 10 superior courts in the state. And so now we are going from staffing 10 courts to staffing 31 circuit courts. And most of the counties now will transport defendants to the courthouse. And so we don't have to do this giant struggle of trying to get in touch with our clients at the jail, either by, by phone. Going to the jail is sometimes an option, but often not an option, because if you're at the jail, you don't have access to talk to anybody else. So you can't talk to the prosecutor, you can't, or it can be very difficult. In a lot of cases, it's impossible. There might be one or two houses of corrections that allow you to, write emails or something from the jail. But so anyway, being at the jail is usually not much of an option. And so currently we're able to send attorneys to the courthouse to staff those arraignments. Come January 1, again, it's going to be spread out over 31 courts. Defendants are by and large, we've been told, not going to be transported. They're going to appear by video. And so we're going to have to do this struggle every morning to try to talk to these clients. We have to wait to get paperwork to have something to talk to them about. And so then a lot of times the window between when we have their charges and when the hearing is supposed to start is very small. And you might have telephone access, but there might be one phone line, and you're fighting against everybody else who wants to use that phone line. It's a huge logistical issue for us, the shift back to circuit court. I mean, in other ways that are not really relevant here today, we're excited that, these are shifting back to circuit court. We hope that that will lead to, quicker resolution of cases. And I think that was a big point of bringing them back to the circuit court, to try to shorten the timeline of life of these cases, to try and resolve them. A lot of felonies get resolved excuse me, as misdemeanors in Superior Court anyway, so why don't we do that sooner in the process? So there's a lot of advantages of it. I don't want to make it sound like I'm against, the return to circuit court, but it does present a lot of logistical challenges for us that it's just going to take time. It's going to take attorney time. It's going to take support staff time. That's a big change that we are preparing for come January 1 anyway. We are hoping, right now, the public defender, unfortunately, statewide does not staff incarcerated misdemeanor arraignments statewide. We do it in some parts of the state where we can, but in other parts of the state, one office covers 6 different circuit courts, and they simply just cannot send attorneys to 6 different circuit courts to cover these misdemeanor incarcerated arraignments. Now we are hoping that all arraignments, incarcerated arraignments, are going to be out of the circuit court. They're all going to be by video. We are hoping to be able to staff incarcerated misdemeanor arraignments more than we currently are. And so that will be an increase in our workload. And then if we add, again, this list of offenses, then that's another increase as well. I think that, well, you could say, well, and not that you are offering this, but, once it will give you more money, okay, that, sure. But it doesn't make staff appear. Certainly I think that, we've done some adjustments to our pay. If we could do more, that could potentially help with retention. But at the end of the day, we need bodies, we need the people. And so it's not necessarily just about money. So I guess kind of shifting to, because I understand one of the reactions to this might be to say, I hear what you're saying, we get it, this is going to be, but this is what we have to do for public safety. This list of 12 to 13 offenses, these offenses are so serious that sometimes you just have to make the law and then make it work. And so I definitely want to speak to that point, because I don't believe that to be true. The list of offenses, certainly I am not trying to minimize the seriousness of those offenses. Number one, if they are proven to be true, right? And one thing to keep in mind is that when we're talking about bail, all of these people are presumed innocent. And so that's, that's a very big factor. But even not assuming that these folks are guilty, but assuming that, that these are potentially serious offenses, some of these folks, might need to be held. And don't get me wrong, this list of offenses, people do get held for these offenses under the current statutory scheme. So that's, that's one of the points that I want to make. I know you've heard that, it sounds like maybe you're hearing a little bit that the bail commissioner system is broken. I mean, the bail commissioner system is not perfect, but it offers a lot of benefit in that it's, a relatively quick way to assess somebody for whether they are appropriate for release. And, so it's not as if seeing a bail commissioner means that you're never going to get held for those offenses. This list of offenses, this list of 12 to 13, people get held for these offenses all the time, and then it goes for a judge, and they do have a bail hearing. But the fact that there are people who are charged with these more serious offenses, with aggravated felonious sexual assault, with, possession of child pornography, with second degree assault, domestic violence. The fact that those people see a bail commissioner and are still released tells you that those are not people who need to be held. And this list of offenses, and I'll talk kind of separately about people who violate bail, and I can address that. But in terms of just looking at their charges and saying, look, you don't deserve to see a bail commissioner, you need to see a judge, you need to be held. I think that it's easy to sort of rely on anecdotes in that regard. But, to say that, oh, this particular offense, here's this one thing I read about in the newspaper, that person, I can't believe that they were released on bail. And I think some of that comes back to more of the people who are accused of violating their bail. But in terms of, these lists of offenses, number one, there is in the fiscal note to Senate Bill 252 gets into this in particular. There are misdemeanor charges that are on this list. And so the idea that you would not be able to see a bail commissioner and that you're going to be held per se, just held on misdemeanor charges is, we would be incarcerating people who would otherwise never be incarcerated. And some of you might have, seen research about, even 2 nights in jail and the, terrible impact that can have on your life, the way it can just make your life unravel in terms of losing housing, losing insurance, losing jobs, losing child custody, and then also the trauma associated with spending any time in jail. But beyond that, the fiscal note for Senate Bill 252 talks about the incredible volume of bail hearings that will result in. And I can say unequivocally, if domestic violence under RSA 631-2B is just per se, you don't get to see a bail commissioner, that will result in just an astronomical number of bail hearings that the system is just not at all prepared to absorb. I'm talking about the misdemeanor level in particular. And then also I want to kind of talk to, I know I again don't want to be seen as kind of minimizing, oh, it's just misdemeanor domestic violence. Any domestic violence, if it's true, needs to be addressed. But these charges, misdemeanor domestic violence is any unprivileged physical contact. Not to fight anecdotes with anecdotes, but I can tell you my first bench trial when I was a brand new lawyer was on a misdemeanor simple assault domestic violence charge, and my client was charged with a shower poof, the fluffy little poof. He was charged with throwing it at his partner, and that was a misdemeanor domestic violence charge. And that's not just an anecdote. I mean, it is literally, if I brush past your shoulder as I walk through a doorway, there's just any unprivileged contact, and that's what we're talking about. I'm sorry, knowing. Yes, it can't be, it has to be knowing. Yeah, not necessarily intentional, but knowing. So, and then also when we look at like misdemeanor stalking under 633-3A, I think that stalking often conjures up an image of somebody, hiding outside in your bushes, behind, in front of your house, sitting in their car, waiting for you. Stalking is essentially, if you violate a no contact order. And so almost the vast majority of these are, text messages and phone calls. And a very good percentage of those are actually contact that is initiated by the alleged victim that the defendant is responding to. which again, this defendant has either a bail order or a protective order, something that says that they're not supposed to do that. So I'm not saying that these charges come out of nowhere, but when we think about are they a danger to the community for sending a text message, the answer is no. Yes, that's correct. It's actually, right, so it depends on how the police department or the prosecutor's office charges it. But a lot of times, the stalking is used for that purpose. That's correct. And then, to move on to, even second-degree assault under 631-2, those offenses can similarly be, minor, relatively minor in nature, contact that does not result in any kind of injury. I think that often in the domestic violence contact, those are allegations of choking. Often there is really no evidence to support that. And we often in contested bail hearings, win contested bail hearings, because of lack of evidence, but also because it sounds, when you hear the word choking, it can sound more serious than really when you hear a little bit more about the facts of the case, and in combination of hearing more about, the fact that a defendant, has a place to live that is nowhere, has nothing to do with the alleged victim, has a job, has other factors that make them a good candidate for bail. These are, again, people that the bail commissioners are seeing and are deciding that they can be released, that they don't need to be held. And then even again, the more serious offenses that are listed here, aggravated felonious sexual assault and felonious sexual assault, and possession of child abuse, sexual images, or computer pornography, those charges, often those clients, those defendants are getting bail, and that might be surprising to folks. How could you be charged with rape or possession of child pornography and get bail? Again, I think I would come back to number one, that the presumption of innocence. But a lot more than that, it is very common for charges in those scenarios, particularly AFSA and FSA, to be old. The allegations are from several years prior. They are not recent allegations in a lot of instances, for various reasons. So often, the defendant has no contact anymore with, with the alleged victim or their family. And then again, these are often people who have other factors that make them good candidates for bail, because we're not punishing them at this phase for committing this offense. We're deciding, are they, a safe person to release into the community? And these people charged with these offenses very often have no criminal record, and have stability, have housing, have jobs. And then also have the ability to add a number of bail conditions that assure, for instance, no contact, but also can assure that they not use electronic devices, as particularly in child pornography cases, and things like that. So there are bail conditions that can be set for these folks. And I think in my 16 years of experience, people charged with those higher level offenses, AFSA, FSA, the child porn charges, are actually not prone to violating their bail or even their conditions of bail. These are not the folks that we are seeing, you hear about this kind of revolving door, and those are folks who are struggling with substance use disorder and with homelessness, and that, who are charged with possession or thefts or things of that nature that are related to their substance use disorder. These are people who, again, have a lot more stability and are good candidates for bail, and who follow their bail conditions. When you tell them not to have contact, they abide by that, and they largely, remain out on bail, because the alternative is what you just heard about, that previously, is that there's people sitting in jail for more than a year pre-trial, who otherwise, potentially with some of the options that you seem like you were exploring here in this committee, like electronic monitoring and pretrial services, would have been an excellent candidate for those kinds of programs. I don't work in corrections, but you asked the question, is that a cost savings, those types of programs? I believe that they are, and a cost savings also, to the public defender program as well. And that kind of leads into, the next category, which is, people who violate their bail, and how do we address the idea that, there's people who kind of come back again and again. Number one, I haven't seen a lot of data that really actual hard empirical data that demonstrates that this is somehow, that there's been a spike in this happening, that there's some sort of, epidemic of bail violations that are going around. We have very real substance use disorder problems in this state. We have, actually a big mental health crisis. We don't. Yep.
Can I ask you a question about the data?
Yes.
Do you have a source of data that we're not available, because we can't, it doesn't seem to be a place you can get data.
That's kind of what I was saying. I haven't seen data that actually
It
says.
doesn't exist.
Yeah.
So we have to rely on what we hear from the law enforcement, from the bail commissioners, from the jails. I mean, I hate to rely on anecdotes, but that's all we have, because we don't have a way to pull data based on the fractured court system we have. So if you have a good source of data, we would love to hear it. But
So, sure. So, I mean, my system doesn't provide for tracking, like if somebody was out on bail and returns, to jail. From my system, I don't have the ability to track that. And so I certainly appreciate your point. Then, what else can we do? I guess I can share my perspective then, doing this work for 16 years. Certainly the opioid, pandemic that we suffered, or we're still suffering in this state, has increased, people who are sick and who are struggling. And I don't, from my point of view, I have not seen some sort of explosion. It's been pretty persistent. I mean, there is a population of people who struggle with homelessness, in particular. I think because right now we're talking about, violating bail by almost always committing a new drug offense, or maybe you missed court because you're homeless, and then when you get arrested on that warrant, you have drugs in your possession, a small amount of drugs in your possession, and so. I want to emphasize, though, that the current bail scheme already has solutions to those issues. There are ways to revoke bail if it's serious enough. There are ways to factor in failures to appear when deciding on bail. There are ways, certainly if you get arrested for a new offense and a bail commissioner sees that you're already out on bail, he or she might not release you and might have you wait to see a judge to decide if you should get out. So there's already these mechanisms that exist to deal with people who are accused of violating the conditions of their bail. And by and large, the people who are accused of that are not violent people who are out committing new violent offenses. These are people who are just still struggling with their mental health and with their substance use disorder issues and with their homelessness. And so the solution for that is not to hold them in jail. And I don't just say that from my public defender heart, right? I say that it doesn't work. It just doesn't solve anything. And so given that these potential changes to the bail statute would cost, I think would result in costs to the public defender, to prosecutors' offices, to the courts. And it sounds like you were already doing this, but I would encourage you, if we're going to incur costs, it should be to spread pretrial service programs. I'm familiar somewhat with the programs here in Merrimack County, the program in Stratford County. They are excellent models. And I think that, much like now drug court is statutory and statewide, I think that pretrial services should be statutory and statewide. I think that, diversion programs, so those are programs where it's essentially if you complete a pretrial services type program or a diversion or this type of program, supervision pretrial with conditions, with treatment, with a treatment plan for you. If you complete that, you can avoid you can avoid conviction. And I think that those are the areas that we need to focus on. And those are areas that are much easier for my office to staff, right? We can deal with, even if the client has regular planned, scheduled court dates to comply with their pretrial supervision program, which largely they don't. Usually, once somebody's put on pretrial services, we, the public defender, the lawyer, obviously, that's our client, and we keep in touch with our client and we work on their case. But we don't necessarily, it doesn't cost us, extra time or money for our clients to be on pretrial services. Now, if they're violating that, then, we might have to have a hearing in front of the judge about that. But again, that's a scheduled hearing, and it's not one of these same-day hearings that are so very difficult for our office to staff. Those are the areas that I think that, to the extent that there is a desire in the community to address, people who are not complying with bail conditions, who are alleged to have committed new offenses while out on bail, those are the solutions that are actually going to impact change, because not only is that person we're going to save money by not just warehousing that person, like you just heard, spending money for medicating them and treating, as you just heard about, when you get to jail, then they start helping you with medical issues that have just gone unaddressed for a very long period of time. But I think also, it's not going to address recidivism if we, even if we hold this client because they violated their bail, they're going to be released. They're not going to get life sentences for possession of drugs and then possessing more drugs while you're out on bail. You're going to get out. And these are people who largely, another reason I want to come back to why, judges are not holding these folks is not because they don't care that they're not violating their bail. It's because these offenses are just simply not worth jail time. And so to house them pre-trial for things that, if they went to trial and they lost, they still would not get a stand committed sentence, is really unjust and not cost effective. So if we invest in these other types of programs, it will hopefully, and not for every single person, but result in kind of breaking this cycle. And not, so if we say, okay, you violated your bail, and so you're going to sit in jail for 3 months while either you work out a plea agreement or we have your trial or whatever, you're still going to get out after that 3 months. And if all we've done is hold you in a jail, and some of the jails do have programming, but there's a lot of research about programming in carceral settings are not very effective, not nearly as effective as treatment in the community. But also, and a lot of times, this availability of programming, particularly pre-trial, there aren't many counties that have pre-trial programming. It's for sentenced individuals. They're just killing time in jail, and they're having minimal to no treatment. And then they get out, after we held them because they, violated their bail, they're still going to be released in relatively short order without anything. And this cycle just continues over again. So I do think that, again, to the extent that we want to address these issues, creating a long list of offenses where you can't see a bail commissioner, to me is not, it's not just, but, it's also just logistically, very, very challenging for the public defender, for the whole court system.
Jails aren't drug-free places.
Correct.
So the concept of opening someone in jail because they're not going to necessarily dry up in there.
That's correct.
With regard to the list of crimes,
And I'm sorry if I can even add, I mean, sometimes people meet new contacts in jail. And so they meet more folks who are also struggling with substance use disorder. And, those are more people that they get out and use with, or, have connections to get drugs and things like that. So, yes.
dealing with the reality some changes. With regard to the list of crimes, keeping away from just particular, let's just talk about classes.
Hmm.
If we took away all the misdemeanors, that would certainly
Yes. Yep.
but the misdemeanors where someone probably likely would not get jail time or they convicted anyway,
Correct.
could result in someone being held for months. Doing time on something that wouldn't be time.
Absolutely. And also, in all kinds of cases, but particularly these misdemeanors, cases where the victim does not what the victim wants either.
So, based on what we've heard, I get the impression that this is societal outrage isn't because of people committing these lists of crimes. It's because of the people violating their bail, getting back out, get back out. Some of these crimes are serious public issues. You have repeated shoplifting. And I understand that's the people with product problems most of the time. Repeated trespassing, disorderly person, things of that nature. Those are what's really driving this, in my opinion. How would you suggest that we would deal with that? Status quo, obviously, is not.
Sure. Yep. So sure. And that's where I come back to, more and more robust pretrial service programs, diversion programs. We're lucky to have drug court. And I think across the state right now, we employ, number one, there's several models of drug court. So we employ kind of a post-sentencing, high-risk, high-need model across the state. But there are other models. There's even pretrial models for drug court. And then there are drug courts. You can have a low-risk drug court. So for essentially like a different kind of diversion type of program. Maybe you still get a conviction. But, I think that there's a lot of options on the table for treatment courts. And then, frankly, to the extent that society wants to do something about this, I've talked more about substance use disorder, but less about mental health issues. But that's a huge driver of this as well, particularly when you're talking about these sort of trespass types offenses. A lot of times those are folks who are just actively mentally ill and go back to places because of, their mental, and I'm not talking about victims' homes, but, they loiter in the same doorway of the same business every evening and, those kinds of things. The New Hampshire just really doesn't have much to speak of in the way of mental health treatment. And so if any solution is going to cost money, and so why not put the money on the things that are actually going to be effective? And to me, that's these, court programs, but also investment in our mental health system, which right now, and I'm sure this is not news to anybody, you wait for 6 months just for an initial appointment for mental health. And for people who are, actively very symptomatic in the more, more severe mental health issues, there's just, even if that person says, fine, I want to go to the hospital, please, there's nowhere for them to go. So that's where we need to be investing the money.
I think the challenge for the committee is that even if we had a magic wand and said, okay, we are going to create a 500-bed mental health facility, it would take 10 years to get built.
Sure.
So we need more immediate solutions to help deal with it. The pretrial sounds a good way to start. What do the pretrial programs that you're aware of, that you are aware of, how are they dealing with mental health challenged individuals like that are committing these, for lack of a better term, nuisance crimes that are making the paper every day, that are causing people to complain?
So I think and it might sound minor, but it is not, but that they offer is case management, is somebody who is actively working with that individual, who's having contact with that individual. And I can tell you anecdotally, but also I've seen research, just having one person in your life who, checks in on you and reminds you about your appointments and, reminds you about your medications and cares about you, that can make all the difference. So it's access to case management. It's also, you can wait, and certainly pretrial services does not make mental health appointments, fall out of the sky. But there are options that a lot of clients either don't know about or have barriers to accessing in terms of emergency appointments for medication. So it is possible, even if you have to wait for therapy, long term, term. There are ways to get access to medication on an emergency basis that clients, either don't know about or, have trouble with the follow through. Again, with the case management that can provide. And frankly, the consequences that comes with, pretrial services also, that's part of the model is that if you're not abiding by these conditions, there are consequences. So that's how those types of programs can help.
As far as you're aware, do most of your clients have cell phones?
Yes, some of them have, some of them don't, but I would say most of them do. Some of them, work only on Wi-Fi, but they're adept at, making that work for them. Yep.
So we've heard testimony of other states where they have these text message programs where the court implements,
We're already doing that.
the
public
Public
defender.
defender's office
Yes.
does that?
Yes.
Have you found that to help at getting people to court on
Yes.
time and not missing and getting
Yes.
these repeated defaults?
Yes, we just started it. We rolled it out, I think, at the early summer, yes, anecdotal. Again, I don't have data in front of me, but anecdotally, I think yes, it is helping.
And that's run by your office, so, and you represent 85% of the criminal defendants in the state, so at least 85% of the defendants, perhaps 83, the other two don't have phones, but are getting a text message. When do you send the message?
So I believe it goes out 2 days before, but I can get back to you with that exact
So
answer.
that's that one message 2 days before?
Yes. I'm sorry that I should know this. It might be 2 days before and one the day of. I can
Is it an
definitely.
automated system?
Yes, and you can't reply to it.
Yeah.
Yeah.
Well, no, it might be good if you set it up to do the morning of, the night before, maybe the hour before.
Right. And it might even be the 2 days before and the day of, but I can get back to you about that.
With regard to clients getting to the court, the vast majority don't have cars, is my understanding. How do your clients find a way to get? I know we went to court at the beginning of the session to observe a Monday morning hearing at the circuit court, and we saw a lot of defaults. And
Yep.
I'm assuming a lot of that people just didn't have rides or they didn't arrange for rides.
Yep.
Some of them don't know where the next meal's coming from. So
Right.
how do you assist, if you do, your clients getting there? Short of, actually, I know you don't pick them up yourself.
Yeah, we're not allowed to do that for liability issues, but in certain places, obviously, the courts are not far from, like in Manchester, the court is easy to access, but there's plenty of places throughout the state where it's not as easy. So a lot of that is, again, it comes back to, the attorney as kind of case manager in that instance, like calling the client, being like, what is your plan? Okay, well, do you have a friend? Do you have a family member? Okay, you don't. Let's look at the bus schedule. Or, we have clients, and it's very, very frequent, who walk huge distances. But I think a lot of it is about providing that support, because if they just don't have a car, or a lot of times it's that they don't have a license, so they're not allowed to drive, is doing that troubleshooting with your client ahead of time. And again, that's where pretrial services can step in, where we don't have the capacity to do that, for every client, every time, pretrial services or other solutions. But there are a lot of defaults, but I gotta say, clients by and large come to court. They
Some
make it
point.
work. Yeah, they understand that they have to figure it out. I have to get a ride. I have to just walk.
Okay. Questions from the committee? Yeah, sure, Representative Catherine. Harry Catherine.
Thank you, Mr. Chair. Thank you for taking my question. You mentioned that there's the text messaging. Do you have any data on how well your office is doing with that?
I don't right now. No.
But is it something that you could get?
I can't, we don't track data of when, we don't track data of when clients come to court. I guess I have the ability, I think, if we close the case for a warrant, I have that, we can run a report that shows cases that are closed with warrants. So I could potentially run reports to see if cases are how that stat has looked now that compared to before we had text messaging. I think I could.
Okay, that would be good to have.
Okay.
Thank you.
What's the average caseload of your attorneys right now?
So, by contract, caseloads are supposed to be around 70. Right now, right now, it depends on different pockets of the state, but anyway, but 85, 95, 105.
Cases active, ongoing
Yes.
at a time?
Yes.
So 75 to 105, depending.
Yeah.
And what are your prospects for getting new attorneys by January?
We did just, we started a new class of lawyers, you typically, not all, but typically brand new lawyers, and they started in August. So we have, a group of lawyers that just started, but we were hoping, as we always hope, that increases our numbers. But as attrition continues, it just barely or not even keeps us at break even. We are, advertising, statewide, but also nationally for lateral attorneys. So those are attorneys with prior experience. We have a federal grant that actually, I don't know that we could use that for new hires, but we are covering some of our current lateral hires. The Judicial Council helped us obtain that grant, and that's been wonderful. We are right now. We have a committee. We are looking at ways to actually be even more aggressive in our recruiting. We have a lot of success in recruiting law school graduates, but with the experience that you've heard about, the experience that's walked out at the door over the last 3 or 4 years. New attorneys are wonderful, but we need to replace some of that experience, and so we are looking at strategies to be even more aggressive with hiring lateral attorneys.
Yeah, I think the corporate world calls that brain drain.
Yeah.
Yeah. Is there any programs in place that attract students that may, or even some people with experience? Because I know a lot of attorneys carry student loan debt for a number of years to help offset some of their debt.
So yes, there has been for a very long time a federal program where if you work as a public defender or a prosecutor for 10 years, you can get loan forgiveness. But 10 years is a long time.
Yeah.
And there's more money in the private sector. So some people on balance would rather go to the private sector and give up on the loan forgiveness. I know that obviously there's been a lot of effort to increase loan forgiveness, and that would be wonderful.
I know that, and this is just off topic, but I don't know if you thought about it, but a lot of attorneys leaving the JAG Corps are looking for jobs. I don't know if you recruit with the military or not, but there's a lot of people decided, I don't want to go defend people in Afghanistan. I think I'll
Right.
come home. And
Right.
so just a thought. Question from the committee representative, Rhodes.
Thank you, Mr. Chairman. I'm just trying to get some clarity because we've heard from pretty much every single person that's testified, which we have also learned that there is not a mechanism in New Hampshire to track who is on bail or who is not on bail. So with that being said, and then if I heard correctly, you had said that you don't have a lot of people that are repeating, like breaking their bail conditions. So I'm a little bit confused on
No.
how that comes about.
Sure. So I mean, when you look at what percentage of folks, that we see that, pick up new charges while they're out on bail, certainly it's higher than I understand that the community wants it to be. But as a percentage of the whole, it's not as if, there's 80, 70, even 60% of folks who are committing new offenses while they're out on bail. But I think also my bigger point in that regard is that I haven't seen, a spike in this occurring, that this is unfortunately a constant that I've seen from the beginning of my career, that folks who struggle with mental health disorders and substance use disorders and struggle with homelessness are going to have issues with, picking up new offenses. And to me, I haven't seen that necessarily change very much. That there's always been people who have mental health and substance use issues and struggle with coming to court or struggle with, still using drugs or still, committing, thefts to support drug habits. But that to me I haven't seen changes to that's been pretty consistent.
Well, I think you would probably agree, though, that as a percentage of the whole, they're not increasing, but the number of people that are in the system is increasing. I mean, it has to be with the opioid crisis. You have more people that are substance addicted now than ever before. With the mental health is spiked huge. So that has to be driving a larger increase in the sheer number of people who are in the system versus perhaps 15 years ago.
I mean, I think actually, if you looked at the number of criminal cases that are opened, not just by my office, but that are handled by the courts, the number has actually decreased every year for about the past 10 or 15 years.
So what do you think is driving the public? Is it a combination of the homelessness, the drugs?
I think
And-
I will say, I think it is more visible. I think, if you walk downtown Manchester, it's visible, right? There's homeless people there, it's more visible than it was, years ago and years past. And I'm not trying to say there certainly there is, an opioid epidemic in New Hampshire. There are a lot of ill people. People are sicker than they were when I started this job. More people are more sick than when I started this job. I certainly do agree with that. But I don't necessarily think that, these issues are new.
Thank you. Further questions from the committee? Representative Pratt?
You answered most of my question, but I
tried to
have
think of
one.
everything.
You did good, yeah. I have one question for you. Isn't the attorney shortage an ongoing thing with the defender's office? Doesn't people come in, they do the job, and they don't stay forever, they leave and go on? Is that the way it's always been?
So no, I mean, yes and no. So yes, this is always can be, a starting point for people in their career. So yes, that is true. But this has also always been a place where people come and spend their career, and that this is what they want to do. And we have, I think I just looked at it not too long ago. Something like 30% of our staff lawyers have been with us for 12 years or more. So we do have people who make a career of this, and those are some of the people that we were losing. But just kind of across the board, the reason I say, that it is different is because starting actually a little bit before the COVID pandemic, but certainly during the COVID pandemic and since then, just attrition has truly spiked. We have not seen quite these levels of attrition that we're seeing now. I can tell you, for example, in fiscal year 2018, 7 attorneys departed the public defender. And then in fiscal year 23, 22 attorneys departed the public defender. So,
Thank you.
So would you attribute that more to just burnout because of the caseload?
I think burnout and pay.
I know that many attorneys will go to the public defender or the prosecutor's office because firms are always looking for people with trial experience, and that's where you get trial
Yeah.
experience. So they'll stay a few years to get that, and then they'll go. But what you said earlier, there is a percentage who just want to be public defenders or
Correct.
just want to be prosecutors.
Yes.
What is the pay parity between a prosecutor and a starting attorney in your office?
Yep. So, and we have looked at that. We were able to do so during the pandemic. We applied for, I wasn't in my role at that time, but we applied for sort of emergency funds to do a cost of living increase. And so we were able to do that. The budget that we just received for July 1 allowed us to continue that, to make that permanent, and also allowed us to do a further pay increase. So we have been able to increase pay over the last, since 2022. In terms of parity, we are still generally, we are now more on par than we were before, but there's still certainly, depending on which county, we look at county attorneys' salary, and actually, city prosecutors actually a lot of times make more money than both public defenders and county attorneys, which is interesting because they're largely they're prosecuting misdemeanor and violation level offenses. So our pay parity has gotten better, but particularly for our starting steps, there's more work to be done.
Does the prosecutor's office that you know of suffer from the same levels of attrition or inability to attract new attorneys that you do?
Yes, I believe
they're-
so.
They're short as well,
Yes,
and their caseloads are probably similar?
they have to be, I would assume,
Yeah,
yes.
okay, thank you.
Or they might even be higher than ours, because I'm not trying to at all minimize their work, but, they don't have the individual clients that I do. So I think that just the raw number might actually be higher than ours.
Okay, thank you. Any further questions? Oh, Representative Wheeler.
Thank you, Mr. Chairman. So say we were able to pass this list of crimes and then the influx of cases were to happen to the public defender's office, what would that look like individual to individual? Would there be people who lose their constitutional right to a defender in a trial and then just go to the trial without defense because they sort of get lost in the deluge of caseload, or would they just have to wait until getting a trial, still sort of green to the whole system?
The latter. So, the court can't proceed with somebody who is eligible for an attorney, for a court-appointed attorney, and doesn't have one. That, the court can't proceed and won't. So, in terms of if we're going to have to divert resources to covering same-day bail hearings, I don't want to say for sure, but one of the possibilities is that, other categories of cases might have to wait for their attorney. We might go backward to where we were, a year and a half ago with, 1,100 people on hold waiting, for their attorney. And I don't want to make that seem like that's going to be our solution and that's an inevitability. I don't want to make it seem like a threat, frankly, but it's certainly one of the possibilities. I mean, if covering arraignments on a daily basis is going to take 4 hours of your day, there's only so many hours in a day and there's only so many people we have on staff.
That would be though only, it wouldn't be every day, wouldn't it just be the first business day after the weekend? Where all those who couldn't see a bail commissioner would have to see the judge?
Oh, no, it's every day of the week. So if you're not allowed to see a bail commissioner and you're being held,
Could you shut the door, please? I'm sorry.
if you're not allowed to see a bail commissioner, you get arrested at 2:00 in the afternoon, you're going to be held overnight and have a hearing in front of the judge where you have to have an attorney, and all that whole process that I talked about earlier. So it's
Okay,
not
so
just
yeah.
weekends. It's,
So bail commissioners, when they bail someone, they don't bail them to the next day. They bail them to maybe 3
An
weeks a
arraign-
month for an arraignment
correct,
day. So
exactly.
all those would be next day cases.
Correct.
Okay, Representative Stone.
Just for some clarity for the committee, going backwards, as we say. Oh, sorry, thank you. Going back to January 1st, when we start the old way of doing things, what I envision, and correct me if I'm wrong, but say you get arrested on a Wednesday, you'll be on a felony case, you'll be held, you'll then be seen in court. They'll go over the charges for the arraignment. You'll fill out your affidavit to see if you're eligible for a court-appointed attorney. Then you'll probably end up with cash bail. You'll go to the jail if you don't make the cash bail, and then the public defender's office is going to come involved at some point.
No, so if with no change to the current bail statute, what would happen is you get arrested on a Wednesday, you see a bail commissioner, and you might be released, and then scheduled for an arraignment day a month later. And then you apply for your attorney and you get your attorney. If you're not able to see a bail commissioner, then you are held and you have that next day bail hearing with an attorney. So we have to get involved.
Each day provide an attorney.
Correct.
Okay.
Yep.
That's what I was looking at. Thank you.
Sure.
We've discussed, and I understand that your office doesn't have the bandwidth or ability to do any weekend work. Is there a legal, in your opinion, method of being able to hold or have a judge sit in lieu of a bail commissioner on, for example, Saturday mornings, instead of, in other words, if we said, okay, here's a list of crimes the bail commissioner can't do, the judge has to do them, can the judge hear those without the full panoply of clerks and defense attorneys if it's just a dangerousness hearing for up to another 24 to 48 hours?
I mean, if you create a law that says that they can, then.
Well, our laws can't supersede the Constitution, so I want to make sure that we obey the supreme law.
I mean, Can people be arraigned without counsel? Yes. I mean, but then they would still have a right to a hearing with counsel. And, you know, that would still need to be as soon as possible, you know what I mean, the next business day. And so
So
then
we just
we're
did
still,
Postponing the inevitable.
I think so. Yeah.
Okay. All right. Yeah, Representative Rhodes.
Thank you, Mr. Chairman. Just, so the bill reform, I'm not really sure if this would be bill reform. So it was before when I was elected. So can you explain the difference between how you operated before the bill reform and now, and what the difference would be now if it was reform?
Sure. So before the first reform, there was,
2018.
sure, yeah, before 2018.
Thank you.
We'll say it that way. That's a good one. So before 2018, I think the biggest difference is cash or surety bail. So is surety bail, right? And that's what 2018 really did, was get rid of bail. I lost my words. I forgot not a bail commissioner, but bail bondsman. Thank you. It largely got rid of bail bondsman. There's no bail bondsman operating in New Hampshire, because so before, you know, the bail commissioner, or later, if you didn't see a bail commissioner or the bail commissioner held you, a judge would largely could have the options of releasing you on your personal recognizance, or setting cash bail, or setting cash or surety bail. And so 2018 largely got rid of bail bondsmen, which was, I think, very appropriate, because so say I saw the bail commissioner and my bail was set at $5,000 cash or surety. So what that would mean is I could either post $5,000 in cash, or me or my family member could contact a bail bond company to post a bond. So a bond was at minimum 10%. So on 5,000, I'd have to post $500 to get out. And then there was additional fees. So usually for like a $5,000 surety bond, a family would end up paying somewhere, say $700 or $800 to get that person out of jail. So that was resulting, number one, in people who just could not afford that. And so then, even though judges thought that they were giving people an opportunity to be released, really they were just holding. That was an effective hold on that person. But even for the person who could afford it, that money was going to a bail bondsman, who then, very frankly, would provide no service to anybody. They would not remind clients about courts. If they didn't show up to court, I think we all have a vision of, like, television, the bail bondsman comes and takes you. They don't do that. They wait for law enforcement to arrest you, and then, they collect their paychecks. So they were getting 10% for doing nothing. And so that's why that was largely done away with. So the 2018 reform really focused on either determining whether people were good candidates for bail and safe to be released. And if so, we don't need to set these cash or surety bonds because they're just safe to be released, or they're dangerous and we need to hold them on preventative detention. So that was a big change, as it created, preventative detention bail. And then there is a provision for cash bail, particularly for failures to appear. But there's language in the statute that talks about, the judge needs to make a determination that you're not being held solely just because you can't afford the cash bail that is set. So that was the 2018, bail reform. It largely, it was a move toward, and not fully, but a move toward, like, the federal model, which is you either get out on your recognizance or you're dangerous and we're holding you. So it was a move toward that, which is a lot of states are slowly starting to adopt that model, and seeing that, number one, that money doesn't make people safe. Just because I have $700 and can afford my bail, that doesn't make me any safer than somebody who is indigent and can't afford the $700. But then also just the idea that we should be doing more analysis of really who is safe and who is not. We should be looking at that more than just picking a random amount of cash or surety bail to set for this person. So that's where we are now. And then this change would, like we've talked about, prohibit large categories of people from seeing a bail commissioner, and then resulting in them being definitely held and definitely needing a hearing with a lawyer in short order.
We
I-
want to
can I-
rephrase it?
Well, I'm not trying to sound argumentative, and I'm afraid that that's how this is going to come across. So I apologize. It's not.
Okay.
So I do understand the reason that they went in, I understand the reasoning for the 2018 changes. What I'm confused on is that you're saying your office not being able to handle what could potentially be coming. So I'm just trying to figure out how is it going to be any different from what it was before?
Sure.
Because
Be-
that's my question.
Sure. No, and no, and that's a good question. I definitely understand that question. The difference is that there's still that percent, like people can see a bail commissioner and those are folks, and then they just get released. And it's not as if we never see them, but we don't see them until, they have we call them walk-in arraignments. So that, the court schedules, a couple of times a month, they have these arraignments and then they get counsel. And then we get a court date that is maybe 6 weeks down the road where we have time to meet with that client and start working on their case. And, the first court date that we're attending is a meaningful hearing where maybe we can resolve that case. So that is the main difference. The main difference is they're not going to have this opportunity to see a bail commissioner such that my office doesn't even have to be involved until further downstream in the case.
But prior to 2018, were people just being held? I mean, in other words, I think what the representative is asking is, if you were operating under that system in 2018 and it went back a little towards that now, how would that be different?
So I apologize if I'm not being clear. Even under the prior scheme where there was, surety bail, they had access to a bail commissioner. So there was the opportunity that either they would just be released on personal recognizance or they would get some sort of bail set that they could post and afford, and then they would be released and it would not result in a next day hearing for us. So certainly under the prior scheme where I was talking about, cash or surety bail resulting in some people being held, then, those people actually, because those people still had the access to see the bail commissioner. So it's still fewer folks, right? So even if there were people who were getting cash or surety bail that they could not afford, then we would have to, number one, because it also ties into felonies first, so it gets a little complicated, because it was back in the circuit court, and so they didn't actually have the same access to next day hearings that they currently have. So, but by and large, the answer is that those people, even though some of them still got held because they had surety bail that they could not afford, other people got personal recognizance bail. Or got a surety bond, that they could afford and they could post, so that we didn't have these next day hearings. This statutory scheme that's being proposed here now would create a large category of cases that by definition are going to be next day bail hearings for us, and that did not exist before.
I think that gets it. Any further questions? Seeing none, thank you very much for your
Thank you
time
so
and
much.
helping us out.
Thank you. And Representative Roy, if I have more data about the text messages, can I
Yes,
provide that
absolutely,
to you?
please.
Okay,
I would love
wonderful.
it. Thank you.
Thank you so much.
Is there anyone else here today that wishes to testify before the committee? I don't believe there is. Seeing none, that's it for today. Tomorrow is the last day we'll be hearing from anyone. Last day of public input. After that, it's just us. Obviously, the public's always welcome, but it'll just be us. So, Representative Wheeler.
I brought muffins. So if anyone wants a muffin, it's a raspberry muffin. I made it myself. You're
And
more
they
than
are
welcome to
not,
one.
just to be clear, 420 muffins, Craig. Thank you. Thank you.
Mr.
Well,
Chairman,
there have been people on this committee in the past. Yes.
I just wanted to, if I may, let the committee know that we were able to make arrangements for Cheshire County to come tomorrow and talk with us about the pretrial and all the diversion programs that we have. So bring your pen, because we have a lot of programs that weren't even mentioned from a lot of the other counties. So hopefully we can learn a lot from that tomorrow and be ready to ask some questions, get a lot of questions answered.
And
Thank
I
you.
believe they have some good cost saving from there as well. So that's what we're looking at is at the same time.
Just
Representative
a reminder that I won't be here tomorrow if someone else is prepared to take notes.
Murray. Yeah.
Not I said
I think, I think the Muffin Man. With that, everybody have a good night.